Every elder law attorney can do estate planning, but estate planners can't do elder law. So the joke is we're just estate planners on steroids.
Usually people don't really start thinking about it until there's a crisis, right? And even in a crisis, there's still some time, sometimes, to still put those plans in place.
That's where people say, I don't want to do this because I don't want my power taken away. You're not taking any power away. It only becomes effective when you cannot speak for yourself.
The power of attorney, it dies when the person dies.
Yes.
And that's why the trust, then you have a successor trustee, then you have rights to manage their assets after they've passed.
I get a lot of referrals from Alzheimer's San Diego. I do teach their legal planning class, trying to get people in advance to do this, but sometimes they come in too late.
You're juggling your kids, your career, your relationships, and you're realizing that your parents are getting older. You're starting to worry about who's going to take care of mom, who's going to manage her finances, and who's going to pay for it. Our guest today is Kimberly McGhee with Black McGhee Law Firm here in San Diego. She's going to help us understand the legal documents that you need to have in place and setting up a plan to protect your family. Kimberly, welcome.
Thank you so much for having me.
So you are an elder law attorney, and a lot of people are familiar with what an estate planning attorney is, but most aren't familiar with what an elder law does. So can you explain what the difference is?
Yes, I do make the joke that even attorneys don't know what elder law attorneys do. So nobody should feel uncomfortable about that. What an elder law attorney is the best way to start is from, everyone knows what an estate planner is. Somebody who helps you with your death plan, your trust, your powers of attorney, those kind of things. Every elder law attorney can do estate planning, but estate planners can't do elder law. So the joke is we're just estate planners on steroids.
Okay.
But really what it is there's technically 12 subjects that an elder law attorney is really a specialist in. It's estate planning plus what happens if you don't have a plan. So we help people with conservatorships, we help people with crisis planning, we help people with what happens after. Some of the major focuses for a lot of elder law attorneys are things like, how do we pay for long-term care? If somebody ends up with a diagnosis of a very long-term disease like an Alzheimer's or some Parkinson's or things like that, how are we going to pay for it? Not everybody has $15,000 a month for a 10-year span. So we focus on things like Medi-Cal, veterans benefits, other type of public availability in order to help pay for some of these long-term illnesses.
So without the proper planning and the proper documents, what risks do families face when having to make decisions about healthcare or finances or even their home?
So I'm going to start when you're alive, because the difference between most estate planning and most elder law planning is we focus on your life planning first, your long-term care planning, and then the death planning of most estate planning is a side effect. So what we want to do is we want to think about if somebody gets in a car accident with a traumatic brain injury, right? This isn't just for elders. It's a silly name because it's not. It's for anybody with a disability, which could be any of us. I have no idea when the bus is going to hit anyone. And if I end up in a car accident with a traumatic brain injury, who's going to step into my shoes? Who's going to talk to my doctor? Who's going to talk to my bank? Who's going to take care of my children? Who's going to take care of aging parents, of siblings, of things that I'm in charge of? I run a business. Who's going to do that for me? And so what the planning you want to do is, who's going to be me if I can't be me?
We were talking about, even as a parent, my kids are now, all three of them are adults. So I have a son who's 19. And as parents, we're just so accustomed to taking care of our kids, regardless of their age. And if there's an accident, like a bus, somebody gets hit by a bus or a car, God forbid, but if they are incapacitated at the hospital, you can no longer help make those decisions without these power of attorney for their healthcare directive, right?
Exactly, and it's terrifying, right? So a lot of my friends, their kids are turning 18 these days. And so for their birthdays, they all get powers of attorney. And they always come and they're like, Mrs. McGhee, I don't own anything. What do I need to do that for? And I say, look, when you turned 18, that's the day that no one could speak for you. That's the day that if you get in a car accident, who's going to talk to your doctor? And they're saying, my mom. And I'm like, no, your mom can't. There's something called HIPAA.
And what about marriages, spouses?
Oh, spouses do this all the time. They say, well, my spouse can't. I said, no, they can't. HIPAA still applies to spouses. And we learned that during COVID in such a dramatic way. You know, I would have people call my office. I've been married for 64 years. I don't know if my husband's alive or dead. He's in the hospital and they won't tell me anything. And it's terrifying because you're calling. And so if you're sitting there in the hospital and you're crying over someone's bedside, the nurse is going to take pity on you. Technically, they're breaking the law if they tell you what's happening. I mean, not technically, they are. But they're still going to do it. But during COVID, when you couldn't walk in, that's when we learned how important they were. So having advanced healthcare directives, which is what we call them in California, when in doubt, blame a lawyer. Some people still think of them as the living will. They're all the same thing. The healthcare proxy, I think, is back east. They use that. But it's the advanced healthcare directive, which nominates your power of attorney for healthcare.
And if you are conscious when you go into the hospital, a lot of people have probably already experienced this. The person who is the patient, they can sign a document at the hospital, but you never know if you go to the hospital what the circumstances are going to be. So that's why this is so important to take care up front.
It is very important because most of the time people do end up in the hospital as a result of an accident or a stroke or something like that. Like my dad used to always joke, I was not his power of attorney. I wrote their trust and their estate planning documents, but I wouldn't be in control. I've got some controlling siblings, so I didn't want that fight. But every time he went to the hospital, he would usurp his documents and say, my daughter's in charge. So and that's where people say, I don't want to do this because I don't want my power taken away. You're not taking any power away. It only becomes effective when you cannot speak for yourself.
So when you're incapacitated, legally, you have to have 2 doctors, is that correct?
It depends, right?
Okay.
The lawyerly answer. There's 2 different ways. You can make documents immediate, or you can make them springing, which means 2 doctors deem you to lack capacity.
Okay.
But I want everyone to know, no matter what happens, even if it's immediate, a agent can never overrule the principal. And that's how we end up in places like conservatorships. I don't want people to not do documents because they are afraid of giving up control. I understand that. I am a control freak too. The idea though is if I want to give all my money away to the Nigerian lottery, I get to do that. My power of attorney can't stop me. Only a judge can. And that's what is important for people to understand.
So what happens if someone does lose capacity and legally, and they don't have a power of attorney?
If they don't, then I always like to thank Britney Spears for this. I can't believe I thank her so much, but we in California would have a conservatorship. Other states, they're called guardianships depending on ages. But in California, we have a conservatorship. It is basically a judge deciding who can make your decisions for you. But it is a very big difference. A power of attorney cannot overrule its principal. In a conservatorship, the conservator becomes basically the dictator of your life.
Okay.
So they take away your civil rights to make your own life decisions.
So that's where the POA, power of attorney, becomes really important if you want to have control of your life.
Correct.
And so you were saying that people might be concerned about losing that power of control, and by having that document, but it's actually the reverse.
Exactly. I tell everybody, if you want to stay in control, get your documents in place. Because not only do you decide who's in charge, you now have the protections of, I get to stay in control. But you've also drafted your manual. And I want people to realize that an estate plan is a manual for your life. Who manages your life when you're alive and well? Who manages your life when you're incapacitated? And then how is your life winded down after your passing? That's what an estate plan is.
Let's just say, and a lot of people have this attitude, I'm going to be gone. I'm not going to care. My kids, they'll handle it just fine.
Well, I mean, I do joke. That's why I like to do life planning and not death planning, because I promise you're not going to care. You're dead, right? But you do care because you love your family and you don't want them to have to go through the trauma of, and it is trauma. Any court proceeding is traumatic. You've already lost somebody. You're already grieving. You're already in pain.
You're not going to be in your right mind. You're going to be making emotional decisions when if you plan ahead, you can make logical decisions.
Exactly. And it's really like protecting the well spouse, the surviving spouse. Yesterday, I had a client come in. Her husband passed. She's wrecked. The 3 daughters are there. It was traumatic. And I said, well, you don't need to do anything. And she's like, what? And I said, well, you already did the planning. So there are these things we recommend, but nothing that has to be done right now. Go grieve. We don't have to do all of the things. And it was nice to be able to tell her that. So she was like, okay, one last thing.
And that's what I want to help people with, is to remove that burden by having their plans up front, for understanding what's coming. And usually people don't really start thinking about it until there's a crisis. Right? And even in a crisis, there's still some time, sometimes, to still put those plans in place. But if you can alleviate that and just be a caregiver or a family, or be a daughter, actually be a daughter, be a son, be a spouse, instead of having to put on that other hat of becoming the caregiver. I think that's really important. And people don't realize that. They think we'll deal with it when it comes.
Yeah, people don't realize how much harder it's going to be. The idea that something happens to your loved one and a doctor says, we can't listen to you, go get a court order. And then you have to figure out what that is, and then you have to spend all the money, and it's exhausting and it's harmful, and they don't want to do that. So that's one of the reasons people feel like, well, doctors are pushing me to do this. They're doing it because they've seen the crisis that happens for not having it.
What do people think, that they can't afford this, or they know in their mind, I can't afford this, that's for rich people. Rich people have their documents.
Okay, number one, a trust. If I can say one thing, a trust is more important in California for not rich people than it is for rich people. Medi-Cal has a clawback provision in estate recovery that they will get from your probate estate, but they cannot get from your trust estate. That is something, if I can express to the world, it's important, because all of us right now can end up on Medi-Cal based on the eligibility and the medical crises that could come. And if everything's in a trust, Medi-Cal doesn't get anything back. And that's important, first of all. So it's not a rich people document.
So if someone is applying for Medi-Cal in other states, it's called Medicaid, and they have a trust, will that eliminate their chances of getting approved by Medi-Cal if Medi-Cal knows that they have a trust?
So no, the issue is Medi-Cal eligibility and estate recovery are two different things. The idea, though, is if we're let's say I'm in a car accident with a traumatic brain injury. I have to get discharged to a skilled nursing facility. I could end up on Medi-Cal because I don't have $15,000 a month for the next 20 years. But the idea is, if my home is in a trust, when I die, Medi-Cal cannot collect from that and cannot take my home away from my children. And so that's the protection mechanism. There's a whole lot more involved, so I don't want to get into the weeds, because that's one of the reasons why that document's important for people. It's not a rich person document. It is a probate avoidance device and a Medi-Cal estate recovery protection device. That's what a revocable living trust is.
So can you explain what probate is? I understand it, of course, being in real estate, but a lot of people may not understand the difference between having a trust and going through probate. And then what is the cost of probate?
Probate, it is a lawsuit that you file against yourself after you've died in favor of your creditors and your lawyer. That's the joke I make. But really what it is...
But there's truth to that.
It is. It's a lawsuit. It's a litigated lawsuit. People have a right to fight. It opens the door to the world to look at your estate and to have an opinion about it.
And siblings of multiple marriages, they can all get involved too and increase the cost.
Siblings, creditors, all types of things. The idea is, what it is if I wanted to sell my house, what do? I sign a deed. What can't I do when I'm dead? Sign a deed. So probate is just a judge deciding who can sign your name when you've died. And then after a year and a half or so, then deciding where it all goes.
And the market could be shifting. You could be losing opportunity during that time as well.
You can. And then you've got the fees associated with it. You have to pay court fees, filing fees. You have to do publication fees. You have a probate referee, which is an appraiser fee. Then you've got lawyer fees, and it's statutory.
It's all coming out of the estate.
Yeah, and it's statutory, and they're large.
What if someone doesn't own a house and they don't have a trust and they have very low assets? Would there still be a probate?
There will be a probate if the assets are over 183,000 some change, indexed for inflation, just a warning. Or you don't need a probate if you can do payable on death, transfer on death, those types of... There's alternatives, making joint owners or things like that. But all of that comes with potential problems, right?
But you are not making those decisions. The judge is making those decisions for you.
If you don't have somebody else in charge, then yes. So the idea is that you don't really want a judge to have to get involved, because now you've got you're delayed. And I'm just going to say it. It's California. Our courts are overburdened. They're understaffed, and it is just hard. And now you're grieving, and you've got siblings going, what's taking so long? And then you've got creditors, like credit card bills and everything, calling daily. When are you paying? When are you paying? It's like, I don't know, when the court issues an order, or when I get letters, or when I get authority to sell.
Your loved ones are going through this process, you're gone, but it's very, very stressful. We got so lucky. So my family, most of them live in Iowa, and their attorney suggested that they get a will and not a trust because of their assets and so forth, and Iowa law, which I don't know. And my stepfather died of COVID, and then my mother had dementia. And so she moved into a senior community, and we ended up selling her house to afford that. And I was so grateful we didn't have to go through probate. Even though the attorney told me that probate in Iowa is really simple and you can do it online, it was still something that I was just dreading. So unfortunately, we lost my stepdad, and the circumstances were horrible, but I was really grateful that we didn't have to go through probate. And that was with us making plans in advance. And I begged him, I'm like, why don't they need a trust? But every state is different.
Every state is different. And I have an experience where their brother died here, and then their father died in, I want to say Virginia. It was somewhere back east, but it was at the same time. And so my client was doing 2 probates, one in each state. And dad was the beneficiary of the son's estate. So we had to probate the house here, but all she had to do was go into the courthouse and get something stamped. And then that was all it took in the other state. And so she was so frustrated, and she was double grieving, and it was exhausting. And she just unfortunately couldn't understand why it was so hard here. And that's why we really want to push it. Because I hate to be the bearer of the news. I mean, I carry the burden, and I will always continue to carry the burden, because I understand. I've lost both my parents. I have been through this. It is exhausting. But the more you can plan, the better it is. That's why the powers of attorney, you have to have them. During that crisis, you need to be able to say, I make the decisions. And you have to be able to walk into a bank and say, I'm in charge.
Banks will not work with you without those legal documents.
I mean, just
almost impossible.
Try calling the cable company without being on the bill.
We talked about that, yes.
It's impossible. So you can't access their phone. What if you need to get into their phone and you don't have the passcode, and all the numbers for all the family members you have to call are in their phone, not yours, because you don't talk to, cousin Sandy all the time.
Yeah.
You can't do that. And just imagine how traumatic that is, that I can't even call
cousin Sandy too.
Just those little tiny things, that having this document that, let's face it, the Advanced Healthcare Directive, most hospitals and medical providers will give that to you for free. You don't have to go pay a lot of money somewhere. I don't recommend it all the time, but you can get it, just a plain power of attorney for asset management at Office Depot. Okay. It's not the best because it's just statutory, and there's additional things you're going to want added. So you're going to want to talk to somebody about that. But at a minimum, have that. So this way I can access the bank. I can't do any more complex planning, but at least I can access the bank, and I can access the phone bill, and I can, turn off the, paper. I mean, a lot of our older clients still get the paper.
And without a trust, like if you have the power of attorney, it dies when the person dies.
Yes.
And that's why the trust, then you have a successor trustee, then you have rights to manage their assets after they've passed.
Correct. And now we also have the ability to manage their digital assets as well.
Tell me a little bit about that.
So the statutory rules had changed. So now you can put in your powers of attorney and your trust the power to manage digital assets. So how do you access someone's Facebook? Their emails.
So does Meta get that legal document, and then they have to release those?
Correct. They can they can access it.
But cell phone as well?
Cell phone, all of that. And that's where we've learned, everything's paperless. If all of their statements are online,
you can't access
what do you do? So that's part of the estate plan. When we talk about life planning, our estate plan, we have a binder. It's not very extensive, but I say every year you get the end of year statements. Once a year, take out the old ones, put in the new ones, so that every year your documents are up to date, but you have to do it one day. Once a year, you keep everything together.
Happy on New Year's Day.
Yeah, I mean, and that's what makes it easier. I say, no one's going to keep up with it daily. But what will happen is, I'm going to promise you, in a crisis, when somebody has access to this, that crisis is not as hard. And what I hear in my office is, we went through this with my husband's mom, and it was so awful. But it was not the same when we went through it with my mom because she had everything in place. She was like, it was an entirely different world.
Hi, friends. I want to pause here and speak directly to the sons and daughters listening. If your parents' health is changing, if the house isn't supporting them the way it used to, or if you're stepping into decisions you never expected to be making, you may be trying to figure out who should be helping you right now. Well, there's a lot of voices in this space. The key is knowing which one actually fits your situation, and that's where a discovery call can help. During that conversation, we look at your specific circumstances and get clear on what needs attention first. It's about helping you identify the right next step and the right professional for your situation, so you're not guessing or reacting or carrying the weight by yourself. If having that kind of clarity would steady things for you, you'll find the booking link in the show notes. Now, back to the episode. Can you tell me a specific story or some details around a situation when someone didn't have their legal documents and they came to you and it was too late to implement those?
Okay, so a lot of times this will come in with the conservatorship situation, right? I get a lot of referrals from Alzheimer's San Diego. I do teach their legal planning class, trying to get people in advance to do this, but sometimes they come in too late. So let's say, I just got a call and it's really hard. The wife has been struggling. She was, I make the joke, a nice lady of leisure. She didn't do, she did a lot for the family. She was, she held all the dinners, she hosted all the events, she helped her husband's career, but she didn't do any of the bills. She didn't do any of the planning. She has no idea what bank they're even at.
I understand.
And
that's not very
It's not uncommon. No, and I kind of make the joke, like the husband that's an engineer, his wife laid out his shoes, his suit, made lunch, he's like, I don't even know where there's a washing machine, and then, so there's a lot of generational.
It could be role reversal, absolutely. It could be either side where they don't know what the other spouse was handling.
Exactly. And so she's come in and no idea what to do, and her husband is lost. He was declining, but then he had a major decline. So he is now unable to manage anything. And we have to file for conservatorship. There's no alternative to get access because he had everything in his name. It's half of hers, but everything was in his name. And she's just at a loss. And without the planning, we're actually getting her a fiduciary, a licensed private fiduciary, a professional trustee, shall we say, to help her because she's like, I've never paid the bills before. I can't just learn now at 82 years old while caring for my husband.
Right.
And so we're creating this plan to help her be able to do how to manage her life and her husband's end of life without her getting sick.
Yeah.
Right? Because she's going to get sick if we don't take care of her too.
Right.
So the idea is they would have come in a year ago, we could have created this whole plan, gotten her set up, gotten the private fiduciary, and the husband could have helped kind of walk her through. And
so we're talking about the legal documents to have in place. The party that has the trust has to choose who is going to make those decisions for them when they can't. So they're going to choose the successor trustees.
Correct.
It could be a second marriage, a third marriage, multiple sets of kids from multiple marriages, or maybe the family only has one child. But in any scenario, they have to pick. So how do they decide who that person is going to be? Are they going to split it? Some people will choose two siblings and have them have equal control, which I know that can be problematic. So how do you choose someone, first of all?
So most people come in and say, I want the firstborn son, the caregiving daughter. And I say, no, you're hiring somebody for a job. Would you hire that person for the job? And we're talking about the job of managing your life during the most expensive time of your life. You thought college was expensive? That's nothing. And so that's what you're looking at. I tell people you have to take your rose-colored glasses off for this hot minute. You can put them back on later.
Yes.
But we are going to evaluate our loved ones as who they are, not who we want them to be. We are going to remember who they were at 8 years old. We're going to remember how they act in a crisis. Do they rise to the occasion? Do they fall away? Do they lean on the wrong kind of people? It's just deciding who can manage your life well. If a child's borrowed money from you, it doesn't make them a bad kid. We love them. They're great. But maybe they're not the best money manager. If they have a spouse that is the controller of the family, that spouse will now be the runner of your family. So you have to.
So it's not, if you might have a daughter, but her husband is the one in control of their finances. You're saying if you choose your daughter, that husband is going to have a big say in what happens to you.
Most likely, yes. I joke, I have 2 sons. So my daughters-in-law will be picking out my nursing home. And that's just a reality. A lot of times with that role, the most capable female usually rises to that occasion, whether it's a daughter-in-law, a cousin, or a daughter. It's usually that person. So let's be mindful about that. What kind of dynamics do you have with your children? Think about them at 7, 9, and 11. Did they fight about who got the bigger bike then? Because they're going to fight about it now. And the reason why is because they start grieving. When you get sick, when your parents get sick or die, your childhood person comes back out. It's just natural, right? Grief causes an impact on your frontal cortex. So your reasoning skills go out the window. Your ability to understand the nature and your consequences go out the window. Your empathy can go out the window. Right. And so you want to remember who they are in those moments.
So what if I'm closer to Susie and I trust her and I'm just not sure about George? I'm making up these names, of course. But George might be the better person to have as a successor trustee, but I'm not sure what his decisions are going to be, even though he's more a sound mind. I trust Susie.
Well, we would want to talk about, would they be able to work together? Because co-trustees are not a bad idea. There's a pro and a con, right? Having somebody be joint acting with you is annoying. I say it's annoying because it's the best way to describe it. It's frustrating. Financial institutions now require you both to be in the same room. My brother and I had to open a bank account after my parents died in the middle of COVID. I live in California, he lives in New York. It was a nightmare. We found that 2-week window. I had to fly to New York and sit in the Chase branch. There's Chase branches here,
right?
But they wanted us in the same room. And financial institutions get to make whatever rules they want. And the Know Your Customer rules, because of the Bank Secrecy Act, they're allowed to do this. So it can be annoying to have a co, because they do have to do some things together. A lot of things they'll be able to do alone, but sometimes at the beginning they'll have to do it together. So it can be frustrating.
What about having one as power of attorney for financial and one for health?
I like that. Okay. I do like to have a check and a balance, because a lot of times your financial guy might not be your health guy. They might not be the same brain, because your healthcare agent needs to be able to stand up to authority. It is now the business of medicine, not the practice of medicine. And people need to remember that, and it's okay to say, wait a second, doctor, I don't agree with you, and I want more. Or it's okay to kind of question things. But a lot of people who are good at numbers generally aren't good at that part, the advocacy. So you kind of want to look to see what they're better at. But a time where a joint for finances is also good is, my favorite example is trustee brother, non-trustee brother. Small estate, $450,000 in cash, 2 bank accounts. Very simple. Non-trustee brother asked his brother, the trustee brother, for a copy of the bank statements, text him. He didn't respond for 18 hours. But what non-trustee brother didn't know is that trustee brother's dog was dying. They were at the vet hospital, and he had to put his dog down. In that 18 hours, non-trustee brother's wife said, Sarah at work, her sister stole all the money and da-da-da-da-da. This man hired a lawyer. I can never undo that damage to that relationship. It was fine. It all got worked out. But one brother accused the other brother of stealing when his dog was dying.
Right.
It was so sad to watch. And I thought, you know what? If mom just would have put them both as co-trustees, they would have access to the same information, and there would not have been a fight. So there's no right answer. You just have to look at your estate, the work that needs to be done, and who you're talking about. Like, there's no one size fits all.
Well, my mom was dying. I had a sister call me while I was in the shower, and she thought I was ignoring her. So it's just, not everybody is going to respond in the time that one might expect.
And
so
that's
where disputes come from.
And that's where I talk about the grief impacting your frontal cortex, is your empathy, your compassion center is impacted. And so you can't reason very well at that time. And so you're vulnerable, to outside influences.
Yep.
And we hear more and more and more about bad actors than we hear about good actors.
So why not just hire a financial fiduciary, a fiduciary, to be your successor trustee?
Oh, I have one.
Okay.
I think it's the best plan. It's easy for me because I know them, because I work with them, I represent a lot of them. So they're not strangers to me. And I think that's the hardest part, is that they're strangers.
Do they take into account what the family members want? Does the successor trustee, are they required to take into consideration what the family wants?
The successor trustee is required to follow the documents.
Okay.
They're going to follow your instruction. As I said, a good estate plan is a manual for your life. It's not paper. You are supposed to participate in what it looks like. I want it to look like this. And you put it in the documents. I want to be cared for like this. I want, if I have a caregiving daughter living with me and she's been caring for me, I don't want her kicked out right when I die. I want her to live in the house for 6 months after I die. You know, you can put those things in there. And by doing that, you get rid of all the fights, you know, and it makes it a lot easier.
What are some of the common mistakes that people do when they're preparing these documents?
Not acknowledging who their family members are in advance. They hope they're going to be the people they hope they're going to be, rather than planning them to be the people who they are. And I have that case right now. I had to sign a document right before we came here because Dad, a year ago today, it was signed August 8th, 2014. A year ago today, signed a document, did not come to his lawyer, that unfortunately he hoped his child would make a good decision, and his child did not. And I had to be the bearer of bad news to let his grandchild know that they were, how do I say, their dad is not the man that his father hoped he would be. So it's sad when people aren't truthful with themselves, because when they're gone, the people who are left have to deal with it.
So here's one thing that I encounter, is that the older generation, the silent generation, or just older adults in this phase of life right now, they will prepare their documents and then they don't share them with their children because they think the document will be there, they can deal with it after they die. Meanwhile, personally, when my father-in-law was in the hospital and we were trying to figure out who was going to take care of our mother-in-law and how we were going to do it and who was going to pay for it, there were all these questions, but we didn't know what was in their trust. And they each had separate trusts because it was a second marriage. And there was all this confusion, but they didn't share those documents. And my husband and I had this conversation. He said, well, they don't have to. I said, you're right, they don't have to, but it would have alleviated all this confusion. He said, but it all worked out in the end. I said, yes, but then we had to go through all this, stress, and it was confusing. So what advice do you have for people for your clients who create their trust document and they don't want to share it with their children while they're living?
What I like to tell them is be mindful of what you're doing it for, right? Some people will at least just say, look, it's on the shelf in the office, on the second shelf, get it in a crisis. I think that's helpful. At least tell them where it is. If you're not going to share what's in it.
Yes.
I understand not sharing it because you can change your mind. But I also remind people that if you're putting somebody in charge, it's because you trust them. If you don't trust them with the document now, why are you trusting them with your document when you're incapacitated? So that's really what it is. If it's a lack of trust, then you've picked the wrong people.
And you don't have to tell everybody, but the person that you've selected, having that conversation is very important.
At least letting them know exactly where it is and who to call to implement it.
So do you have any last words of wisdom for what you should do before you have your first crisis?
Yes, please plan. Please get powers of attorney in place. Please consider whether a full estate plan is in your best interest. I do not want anyone's passing to be the reason families fall apart. You spent all of this time building this amazing family. Please don't let your death or your incapacity be the one thing that breaks it down.
Thank you so much. Because there are so many issues that we couldn't discuss today because of time, you probably have some other questions that you want answered. Drop your questions down below. I'm going to invite Kimberly McGhee, Elder Law, back, and we will answer those questions at that time. Thank you.